Hi, my name is Burton. I'm from Vancouver, Washington. I'm here to discuss and tell you a little bit about the problems I've had under civil corruption. In January of '93, I had acquired a piece of property in Vancouver, Washington that was subjected to severe restraints by our county government, which required legal intervention with up to as many as 6 attorneys at one time. Eventually, in 1998, the Washington State Supreme Court upheld the lower court's decision in which Judge Thomas Lodge had ruled that the county's action taking my property from me without compensation was wrong and that they had violated my constitutional rights in doing so. Soon thereafter, I hired my attorney to file a second lawsuit against the county for all the legal fees and expenses and the loss of business and so forth. And I had thought that he had done so, for he had told me he had done so. But some 2 years later, when I finally ended up in court, I realized that the lawsuit hadn't been filed properly or timely, even though he had indicated to me that he had done so. Having lost a substantial lawsuit put me into heavy financial burden, which caused me to end up filing personal bankruptcy at over $250,000. Bankruptcy court requires, prevents a person from filing any legal action because your assets yourself now belongs to the court, to the trustee. And so I was prevented from taking any action against Mark Erickson, the attorney that I was suing for malpractice, until 2 years later. And filing a complaint with the Washington Clark County Superior Court, I drew Judge Robert Harris. Judge Harris, who happened to be the oldest judge in the state of Washington, was also the presiding judge of all the judges in the state and of Clark County. My attorney, who represented me in this malpractice case, attempted to introduce evidence, declarations, affidavits, testimony, and witnesses to the action of my complaint, but Judge Harris refused to do so. Eventually, Judge Harris was served with motions to vacate his early dismissal of my claim against Mark Erickson, but refused to engage in that motion or to write an opinion, which under Washington state law and the Constitution requires him to do so within 90 days. And that is under RCW 2.08.040, I believe it is. So I ended up losing my case against Mark Erickson because Judge Harris refused to enter a ruling on the motion to vacate, which caused me then to file a lawsuit against Judge Harris. And after doing so, I moved the case from Harris to Skamania County, where that sole judge, Judge E. Thompson Reynolds, recused himself. The county officials in Skamania decided to appoint one of the listed AR6 judges, pro tem judges, under the AR6 rule, and that judge also recused himself. The county officials coalesced with the defense counsel, then in moving the case from Skamania County to Lawless County, and assigned it to Judge Stephen Warning, who I opposed and objected to, and several pieces of correspondence went out to that effect. Nevertheless, Judge Warning engaged the services of the county defense and dismissed my claim again, this time against Judge Harris. Further review by statutes and Constitution revealed to me that I would learn that Judge Warning did not have authority or jurisdiction to enter and engage in this lawsuit because he wasn't requested under Washington law to hear this case by Judge Thompson Reynolds, nor was he appointed by the majority of justices of the Supreme Court of the state of Washington, nor was he appointed by the governor of the state. Those three conditions are under Article 4, Section 7 of the Washington State Constitution. Judge Warning had violated that law, and then in dismissing my case, caused me to lose my action against Harris. Since then, I've filed a federal complaint in federal district court, which under RCW 2.28.30.1 requires Judge Warning, when served on a proceeding or complaint or suit requires him to step off the bench. I filed a motion for vacancy of his decision to dismiss my claim, but instead of stepping down, he ruled against me. Now we're back, and I'm about to file a motion for reconsideration next week, and I'm going to be drawing Judge Warning again, because he doesn't want another judge to hear this case, because if he engages another judge under this RCW statute, that judge would either have to dismiss the complaint, the vacancy, or he would have to find in favor with Warning. And if he boards the same train with Warning, then he's just as guilty as Warning. So Warning doesn't want to be put in that position. So now we're in a situation that even if Warning had concurred with me in my vacancy decision, his doing so would be an admission that he did not have authority and did not have jurisdiction, which meant the last 2 years I've been fighting this action have all been for naught. I don't know what the outcome's going to be, but I can tell you, citizens out there, you cannot be complacent about not protecting your rights. Too many men and women have died for this country, have served this country well to protect our society. We need to be on top of this. We need to be informed, and we need to be active. Don't let these judicial officials, these judges, and these lawyers get away with what they're doing. They're ruining our country. And if we lose that branch of government, then the rest of our society goes with it, because there's no protection.